Everyone. We are pleased that you have joined us for today's webinar titled Recent Case Sheds Light on Asset Protection Rules, sort of. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Lineberg, and regularly speaks at industry events. His new book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available on Amazon.com. Linus will draw on his legal, tax, life insurance background, and practical experience for today's webinar. And here he is.
Well, thanks, Jennifer, and good morning, everyone, or good afternoon, depending on where you are. Thanks for joining us today. We're going to spend about 15 minutes discussing the case of Shaw versus Balloch and what it adds to our understanding of asset protection rules. To me, one of the key things about the case is it confirms that federal ERISA protections, while they are not absolute in protecting assets, are pretty stout. But I think I'm getting a bit ahead of myself. Let me set up the background for this just a bit and observe that at Advanced Underwriting Consultants, Jennifer, Larry, and myself, we get a lot of calls from agents who want to ask a general question, which goes something like, I've heard that life insurance cash values or annuity cash values are protected against creditors. Is that true? And most of the callers are asking a simple question because they want a simple answer. And unfortunately, what we tell them almost always is it depends. And that is unsatisfying from a producer's perspective because they want to be able to, I think, tout advantages of life insurance and annuities to their clients. And they also want to give their clients a lot of assurances. But unfortunately, the protections, such as they are, don't apply everywhere and every time. And those things need to be understood in order to be able to serve clients in the way that they need to be served with good information. So clients do want to know how to protect their assets. And when we talk about asset protection planning, we're talking about the legal ability to protect personal or business assets from the claims of creditors. And unfortunately, in the asset protection realm, from a simplicity perspective, this is unfortunate. Each state's got its own rules with regard to what kinds of assets are protected and when. And the laws apply differently depending on the types of creditors that we're talking about. We'll get into that in a second. Now, I'm not suggesting that financial professionals and life insurance professionals punt every time when the client asks a question about asset protection planning and asset protection rules and say, you got to ask your lawyer. I think it's important for us as we're serving our clients to have some information about this and be able to talk to that subject, which I think is the main purpose of today's session, so that we understand a little bit about the nuances and can help the clients navigate as part of their team that are dealing with asset protection questions. So what are the types of circumstances which might lead to different results with regard to asset protection questions? Well, one factor is who is the creditor. And in general, when you look at general asset protection rules, they apply to unknown future creditors almost always. In general, asset protection strategies are most effective with regard to future creditors that the client doesn't know about and can't predict with reasonable certainty, right, at the time of the planning. The general rules will help clients usually in those circumstances. However, if the client already has creditors that the client knows about, asset protection strategies usually don't work with regard to those clients. And if they do work, they'll work with a bunch of disclaimers. In general, if a client makes a transfer to life insurance, annuity, other protected asset that is designed to frustrate or cheat a creditor that the client already knows about, courts usually have the ability, under most circumstances, to characterize those transfers as fraudulent transfers, and they allow creditors to reach those assets. And so a lot of times clients will ask the agent the question about asset protection, but won't say that there's already a creditor that they know about. And so that's one of the reasons why agents and financial professionals need to be really careful about answering those questions. So what kinds of liabilities or what kinds of creditors might asset protection rules not extend to? Well, if you've got a situation where clients are getting divorced, in a lot of cases, the general asset protection rules won't help one spouse against the claims of the other. While an annuity may be protected from the claims of creditors in a estate, the fact that one spouse owns an annuity, when those spouses divorce, it is likely that that asset is unprotected and that asset will be considered to be available to be divided between the spouses in the event of the divorce. And sometimes our clients won't tell us about a pending divorce. We'll ask the asset protection question generically, and we'll hope that the answer that's given will help them in the event of divorce and dividing up stuff. And so that stuff needs to be examined and thought about. In a lot of cases, the IRS or government agencies will have special powers with regard to assets that will allow them to enforce judgments against assets that might otherwise be protected. And so you need to be aware of that. If the IRS or the federal government is the creditor, in a lot of cases, asset protection strategies don't work. So, a lot of times people get confused about what kinds of rules will apply when. So each state's got its own rules about what assets are accessible in the event of a lawsuit. And then they might have different rules, and the federal government has its own rules about what happens in bankruptcy. What kinds of things can be protected in the event of bankruptcy. So what's the difference? Well, state rules about asset protection probably help a client, in the event the client sued, protect certain kinds of assets without having to declare bankruptcy. Bankruptcy rules only help a client if they do file bankruptcy, which has other potential consequences. And so those things need to be sorted out. A lot of times people will confuse asset protection rules with Medicaid planning rules. Medicaid is a needs-based government program that pays out benefits, a lot of times for long-term care expenses, if the person can prove that they are poor. An asset may be protected from the claims of creditors, but still be a countable asset for Medicaid purposes. So while the asset might be protected from creditors, it might preclude, that same asset might preclude somebody from qualifying for Medicaid financially. And so those things need to be thought about and sorted out by financial professionals. And so when your client asks the seemingly innocuous question about asset protection, you've got to dig down deeper and ask and investigate what they're really asking you about in order to give them the beginning of a sensible answer. So all of that is background. So let's talk specifically about the case of Shah versus Bollock, So Syed Shah sued Abdul Balak for breach of contract and obtained a judgment in 2009 for 400 grand, a little over 400 grand. And Shah, after obtaining the judgment, tried to collect part of the judgment from Balak's 401k account, which had a balance of 50 grand. And Shah alleged that Balak had fraudulently transferred several $1,000s into the 401k account after Shah had the judgment against him. And so it feels like under those circumstances that this was a fraudulent transfer, that Shah knew about Balak's claim, Balak knew about Shah's claim. Balak transferred money into the 401k account after the judgment, and it seemed unfair to Shah that the money would be unavailable to satisfy at least a portion of the 400 grand plus judgment that Shah had against Balak. So Wells Fargo objected to the collection, and they said, look, this is an ERISA account. It is an ERISA pension account. ERISA has non-alienability provisions built into it under federal law. And we can't turn over the money to you, Mr. Shah, because ERISA prohibits us from doing that. And the court in Arizona, where the parties argued about this, agreed with Wells Fargo. Well, Shah appealed the judgment to the Arizona Appeals Court, and the Appeals Court analyzed Arizona law, noted that Arizona has strong laws prohibiting debtors from making fraudulent transfers, and looked at the Arizona statute. And the statute, which is quoted here on the slide, says that if a transfer is made by a debtor and it's deemed to be fraudulent, if the debtor made the transfer with actual intent to try to cheat the creditor in any way, it can be undone. And so, the question that Shah tried to raise is, well, you should have tried to figure out, because of this Arizona law, specific statute, whether Balak's transfer to the 401k account should have been undone, because I, Shah, had the judgment. Balak knew about the judgment. Instead of paying me, Balak transferred money into the 401k account. And Arizona's got this statute that says fraudulent transfers can be undone. Well, what did Balak say in response to that? Balak says federal law, ERISA, is an absolute protection for the funds in the 401k account, and it supersedes, Balak argued, that the fraudulent transfer provisions in Arizona. And so this is what ERISA says about pension plans and 401k plans, and anything that is governed by ERISA. It says that ERISA in itself says that a pension plan must provide that benefits provided under the plan may not be assigned or alienated. And the Treasury regulations go on to define what assignment or alienation are. And basically, any claim by a creditor against a plan participant is governed by this anti-alienation provision in ERISA. It can't be done under federal law. And so, the court noted that Balak's retirement plan was a qualified plan and governed by ERISA and the anti-alienation provision. And the court pointed out, when there's a conflict between federal law and state law, the federal law controls over the situation. And therefore, ERISA controlled. And Shah made one more argument, that because of the 2009 judgment, Balak should not have been allowed ever to put money into the 401k plan, and therefore the money should not be protected by ERISA. Shah cited several cases where a creditor was allowed to have access to the funds inside of a qualified plan, but the court rejected those arguments, saying that all of the examples that Shaw cited were situations where the plan administrator did the misconduct. And there was no misconduct of that type alleged in the Shaw case. The liability, the $400,000 liability, was based on Ballock's conduct alone, not by the plan administrator. And so, therefore, ERISA was supreme, and the appeals court ruled in favor of Ballock, finding that the 401k money was protected. So what are the lessons to take from this case? Well, I think the first lesson is that asset protection planning is hard. There are very few straight answers. In this case, you can see the arguments that both sides made. It feels unfair to those of us who have ever had anybody else owe us money, that that the person who owes us money can frustrate us by making deposits into a pension plan. But that is what it is. The federal government and the states have all got ways to protect assets, but the federal government with ERISA makes the protections of pension plans pretty stout, and that pension plan assets almost always are safe, except under the circumstances where the court, which the court described, where there is plan administrator misconduct, and the other common thing is, an ex-spouse having claims against assets. The ex-spouse can access the money inside of an ERISA plan through a qualified domestic relations order, or quadro. So ERISA is not quite absolute, but its protections are really stout. What are the things that we should take away? I think for us to know something about asset protection is good. It can help us serve our clients. Clients who already have a need for life insurance or annuities or other financial products, if there are state laws that strengthen the asset protection characteristics of those assets, I think those can be additional selling points. And so, I think that's good for us to know. But we also need to know that those protections are not absolute. If the client's really worried about asset protection planning, the right advice is always to tell the client to, look, I can give you general information. I know something about the general rules, but for the situation that you're worried about, Mrs. or Mr. Client, you need to have a specific conversation with your own lawyer to figure out what your protections and your risks might be, because the answer depends on the facts that you're worried about and on the peculiarities of state law, which this is financial professional speaking, I, as not an attorney, aren't equipped to answer. And so I think that's always the right advice to give. So I'd like to thank all of you for joining us today. If you have an interest in seeing the article that we produced on the Shaw versus Ballock case, feel welcome to email asktheexpert@advancedunderwriting.com, or if you have questions about today's webinar, feel welcome to contact us then. Jennifer, back to you.
Thanks, Linus. And thanks again for joining us today. And tune in next month on January 3rd for 2018 tax update. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.